Meeting is being recorded.
Great. Members of the council, guests, it is approximately 10:01 a.m. It appears that based upon the joining of the meeting that has tempered just a bit. So I'm going to go ahead and call to order the meeting, the March 6, 2026 meeting of the Tennessee Domestic Violence State Coordinating Council. This is a virtual meeting. My name is Melanie Bean, and I serve as chair of the Tennessee Domestic Violence State Coordinating Council. Today is Friday, March 6, 2026, and it is approximately 10:02 a.m. Central Standard Time. All of our meetings must be recorded and are housed on the Tennessee Coalition's YouTube page. I welcome everyone to the quarterly meeting, which is open to the public. I would ask Brandon Woosley, our council secretary, and who is also serves as the legal director of the coalition, to now call the roll. I would ask each of you to please unmute and let him know your attendance by saying you are here or present.
Morning, everyone. We will start out with Chair Member Melanie Bean.
Present.
Council Member Michelle Consiglio Young.
Here.
Council Member Chelsea Curtis. Council Member Judge Angelita Blackshear Dalton. Council Member Dorisha Davis. Council Member Lena Frog. Council Member Sue Jones.
Present.
Council Member Deborah Lambert.
Present.
Council Member Representative Mary Littleton. Council Member Van Makers.
Present.
Council Member Kirby May.
Present.
Council Member Judge Greg McMillan. Council Member Michelle Mowry.
Present.
Council Member Ashley Parker.
Present.
Council Member Dee Reynolds. Council Member Kendra Reeves.
Present.
Council Member Sheriff Ray Russell. Vice Chair Judge Jenny Scott.
Present.
Council Member Ilana Tate.
Present.
Council Member Bobby Van. Council Member Felix Vess.
Here.
Council Member Senator Paige Wally. And Council Member Brandon Woosley. I am here.
Mr. Secretary, do we have a quorum?
We do.
All right. Thank you, Mr. Secretary. The first order of business on our agenda is to approve the minutes from the December 5th, 2025 meeting. Those minutes from the last meeting were sent via email by Brandon Woosley. Are there any corrections to those minutes? Hearing none, seeing none, with there being no corrections, the minutes are approved as distributed. The next order of business is to attend to our committee reports on behalf of the Nominating and Executive Committee. I can report that the Executive Committee will be meeting between now and the June 5th, 2026 meeting to discuss nominations and/or changes to chairmanships and/or nominations to the executive committee, and that will be presented at the June 5th, 2026 meeting. The next committee is the Emerging Issues and Orders of Protection Committee report. Ms. Michelle Consiglio Young.
Good morning, everyone. So our committee met this morning at 9 a.m. Like we usually do. We went over a few pending pieces of legislation before the General Assembly for most of our discussion. Also, before that, before I get into those, we also discussed the impact and maybe ongoing comments or concerns with implementation of Public Chapter 253 from last year, which deals with the GPS monitoring providers, so the electronic monitoring providers, and just the process and things that some counties are dealing with that new qualification requirements for those GPS providers and whatnot. There are just several kind of ongoing concerns and just implementation things that the different counties are dealing with. I think the three main issues are just dealing with the exclusionary zones and just kind of handling those changing and how law enforcement deals with that within the parameters of the legislation. Also the confidentiality of addresses as they're required to be reported as things change, and also just app usage for those GPS providers by the victims and others, and just just usage of that. Because this is an ever-changing landscape, we've decided we're going to keep this on the agenda just for periodic discussion and follow-up. There had been talk about the legislature taking up is a cleanup bill or just a bill to address some of the concerns, but that just didn't happen this year for various reasons. No fault of anyone's. It's been a fast session, and it's a difficult issue to address. So I think legislators and others are trying to figure out the best way to implement this. So I do suspect that there'll continue to be discussions. Judiciary is happy to be at the table. I know the coalition's at the table on that. So we'll just keep everyone apprised of anything that changes with that. But I just wanted to let everyone know that that's an ongoing discussion that we continue to have. A couple of the bills that we talked about too deal with the lifetime orders of protection. The first is Senate Bill 1938, which would increase the penalty from an A misdemeanor to an E felony for violating a lifetime order of protection when the underlying conviction involves use of force against the victim. So that does have a fiscal impact, so we'll see what happens with that as it goes through the finance committees. But as far as on the subject matter of it, no one seems to have an issue or oppose that. The other one is House Bill 1900, which allows for lifetime orders of protection can include out-of-state crimes if they're the same as ones that are in our books in Tennessee. So we will continue to monitor that. The Senate has passed it. It will be heard in the House this coming week in House Judiciary. And we'll watch that. There was a couple comments about possibly counties and law enforcement, others knowing about a criminal case that may be going with those offenses and just the possible implementation of that. I thought that was a good point to bring up. So as this continues to go through the legislature, we'll just have discussions about the actual implementation of that. And then the last bill that we talked about is Senate Bill 673, which has to do with sentencing a defendant who's convicted of certain domestic violence offenses to attending a batterers intervention program certified by the council. And I know that over the past year or so that there's been issues with the funding for that and just personnel in order to certify those. And actually, I guess it's just the site visits within those certifications. So I just thought I would turn it over to Jennifer to give an update to everybody, because we did have a really good discussion about this in our committee. And I know that it's been an issue that's come up with the judiciary. So I thought it would be good for her to give us all an update.
Sure. Michelle. Go ahead, Jennifer.
Okay. Yes. So as you all know, we used to have a position at the coalition that was able to certify BIPs that was funded through OCJP. OCJP was no longer able to support that position beginning this year. So that meant that there was no one whose job it is paid out to go and oversee the certification and expansion of those BIPS programs. The council still is responsible for the certification, and we continue to have the BIPS committee, who we'll hear from soon. And they now are doing paper monitoring and certification of the program. So there's a pretty thorough application process that each program has to complete in order to recertify, and that's reviewed by the committee. What's not happening are the site visits. BIPS programs do pay $200 to recertify. The coalition receives that money. We are keeping it in its own separate account, and the policy right now is if any complaints are received about a program or if there are ongoing concerns about recertification when the committee reviews the paper application and submitted documents, then someone from the committee, a volunteer from the committee, will go out to do an on-site visit, and the coalition will be able to support their travel in order to do that. So that's kind of where we stand right now with the bill that's going through the legislature. There's a fiscal note on that bill that would allow for the coalition to hire a physician in order to do that monitoring again. A concern that I have seen coming up when that bill, the coalition didn't bring that bill, but whenever it's being talked about in the legislature, is that it requires a defendant to complete the batter's intervention program if there is one in there, a certified program in their county. There are 26 certified programs. There's not a program in every county, so there is concern about inequity in financing. So that's kind of the update of where we are right now.
Thank you, Jennifer. Go ahead, Michelle.
I'm sorry, that's it. That concludes our report from our meeting this morning.
All right. Thank you, Michelle. I appreciate all the work of your committee, and certainly as the legislature gets underway, certainly you and your committee have a lot to track. I appreciate the updates on those Senate bills and the further discussion on Public Chapter 253. Jennifer, also appreciate your assistance in keeping us up to speed on how the BIPS, how the Domestic Violence State Coordinating Council has been affected by the reduction in funding. And unless that is, I guess, addressed by the legislature, then the monitoring of BIPS programs across the state will continue to be affected in some respects. We'll now move on to our Certification and Monitoring Review Committee. And we met this morning, and I will call upon Van Wolf, Councilmember Van Wolf, to give us an update on that committee.
Yes, good morning, everyone. I apologize, I cannot get my camera on. We had 5 programs apply for recertification, 3 of which we approved without contingency, and those are Choices of Franklin, First Tennessee Human Resources Agency of Johnson City, Tennessee Community Counseling Services of Chattanooga. 2 of the remaining programs are pending approval, contingent upon submission of some correct documentation. That was minor. We've given them 30 days to submit that for approval, full approval. And that is the program named CLEAN out of Memphis and MJM Services out of Hendersonville.
Great. So as to Choices, the recertification of Choices in Franklin, Tennessee, which is serving Williamson and Davidson counties, it's my understanding, based upon the committee and council member, that all the paperwork is in order and they have paid their fees in order to be approved for recertification. Is that correct?
That's correct.
Is there a motion to recertify Choices of Franklin, Tennessee?
I make a motion.
All right. I'll second that motion. And Mr. Secretary, would you call the roll?
Yes. Chair Melanie Bean,
Aye.
Councilmember Michelle Consiglio Young,
Aye.
Councilmember Sue Jones,
Aye.
Councilmember Deborah Lambert,
Aye.
Councilmember Van Michels,
Aye.
Councilmember Kirby May,
Aye.
Councilmember Michelle Johnson,
Aye.
Councilmember Ashley Parker,
Aye.
Councilmember Kendra Reeves,
Aye.
Vice Chair Judge Jenny Scott,
Aye.
Councilmember Ilana Tate,
Aye.
Councilmember Felix Bess,
Aye.
and I'm an aye.
Based upon the votes, the motion carries. I would like to make a second motion as to First Tennessee Human Resources, and I should have done this collectively with choices, but First Tennessee Human Resources and Tennessee Community Counseling Services. First Tennessee Human Resources serves Greene, Johnson, Carter, and Washington counties, and Tennessee Community Counseling Services serves Chattanooga and surrounding counties. It's my understanding that the paperwork and the recertification applications for both of those programs are complete, and they have paid their appropriate fee, and they are recommended for recertification by the Certification Monitoring and Review Committee. So I would make a motion to the entire council that those two programs be recertified. Is there a second?
I'll second.
All right, second by Michelle Mallory Johnson. Any discussion? Hearing none, seeing none. Mr. Secretary, would you take the roll?
Chair Melanie Bean,
Aye.
Councilmember Michelle Consiglio Young,
Aye.
Councilmember Sue Jones,
Aye.
Councilmember Deborah Lambert,
Aye.
Councilmember Van Michels,
Aye.
Councilmember Kirby May,
Aye.
Councilmember Michelle Johnson,
Aye.
Councilmember Ashley Parker,
Aye.
Councilmember Kendra Reeves,
Aye.
Vice Chair Judge Jenny Scott,
Aye.
Councilmember Ilana Tate,
Aye.
Councilmember Felix Bess,
Aye.
and I'm an aye.
Thank you, Mr. Secretary. As to the two remaining programs, Councilmember Councilmember Van Wolf, the Clean Inc. serving Shelby, Tipton, Fayette, and Marshall counties, and MJM Services LLC, which I think is based in Hendersonville but serves all Tennessee counties. Did the committee have a recommendation as to the time period by which those two programs would need to resolve any paperwork deficiencies for recertification? Oh, I'm sorry.
I apologize.
muffled
We're going to
just
give
a
them
little bit.
30 days to submit that.
Right. So, and can you identify for the council what the deficiency was for Clean Inc. and for MJM Services LLC?
Yes, give me a second here. Clean Inc. was the free from abuse statement that has to be signed by a staff member was not signed by a staff member, but instead a client. And MJM did not submit a letter of collaboration or support from another agency.
So based upon those two, upon receipt of that additional information, which would be monitored by the committee and Mr. Woosley as that information is received, it's my understanding the committee is recommending that recertification be immediately implemented if they upon the receipt of that additional information. Is that correct?
That's correct.
Based upon the recommendation of the committee, I would move that Clean Inc. and MGM Service LLC be approved for recertification, provided within 30 days they submit the forms that were identified by the council member. Is there a second?
I'll second.
Any discussion? We have a motion and a proper second. Seeing no discussion or hearing no discussion, we would call for a vote. Mr. Secretary, would you take the roll?
Chairmember Melanie Bean,
Aye.
Councilmember Michelle Consiglio Young,
Aye.
Councilmember Chelsea Curtis,
No.
Councilmember Sue Jones,
Aye.
Councilmember Deborah Lambert,
Aye.
Councilmember Van Makers,
Aye.
Councilmember Kirby May,
Aye.
Councilmember Michelle Johnson,
Aye.
Councilmember Ashley Parker,
Aye.
Councilmember Kendra Reeds,
Aye.
Vice Chair Judge Jenny Scott,
Aye.
Councilmember Alana Tate,
Aye.
Councilmember Felix Vess,
Aye.
and I'm an aye.
Based upon the votes, the motion carries. Is there any further business of the Certification and Monitoring Review Committee? Hearing none, we'll move on to the Training and Education Report by Alana Tate or Ashley Payne. I know Alana is on. There she is.
And I'm on as well. This is Ashley. I don't know that we have any numbers to report because we are no longer able to do the monitoring visits.
That is my understanding as well.
Okay. And until some sort of funding is approved, that's going to continue to be a challenge for the Domestic Violence State Coordinating Council. Is that right?
Yes, that's correct.
Any further comment that you would provide to the council based upon those challenges that prevent those funding challenges that permit the council from doing their full work?
No further comments.
Okay. Until further funding can be provided so that the council can fully complete the work. I want to continue to thank Alana and Ashley for the work on that committee. And hopefully there will be some funding relief that will give us an opportunity to fully do the work of the council. That completes our business of committee reports. We have no announcements other than we'll move right to public comments. As a reminder, all public comments must be submitted to the Tennessee Coalition to End Domestic and Sexual Violence at least 2 weeks prior to our general body meeting. We did have 3 comments that were submitted in advance. There were 3 comments submitted in advance of the meeting. 2 of those comments were not submitted within the time period. However, I'm going to announce those were still distributed to members of the committee. That included a comment by Linda McFadden Ketchum. She is a volunteer with the Moms Demand Action in Tennessee. They are a national gun safety and gun violence prevention organization. The second comment was provided by Meg Beauregard. She is a policy counsel for Everytown for gun safety. They are the nation's largest gun violence prevention organization. And there was a third comment that was submitted by a student organization. And my apologies, I cannot lay hands on that right at this exact moment. I had it here in my stack. All 3 of those comments were related to the domestic violence firearms dispossession forms and lobbying the Domestic Violence State Coordinating Council to take a position as to modifications of the Domestic Violence State Coordinating Council. In the effort of, because all 3 comments commented on the same issue. I will read for the committee the comment that was provided by Linda McFadden Ketchum. Says, good morning. My name is Linda McFadden Ketchum. I'm a Davidson County volunteer with Moms Demand Action Tennessee. We are a national gun safety and gun violence prevention organization. Our organization supports updating the domestic violence firearms dispossession forms for orders of protection and domestic violence misdemeanor convictions. The goal of this form change is simple. When domestic abusers dispossess their firearms and elect to do so by giving their firearms to a third party, courts must know that the third party, who that third party is, in order to ensure domestic abusers are following the law. Without this information, as the form stands now, courts and law enforcement are unable to ensure that domestic abusers have actually given up their firearms. The change we are advocating for would require the name, contact information, and signature of a third-party transferee to confirm receipt of firearms and acknowledge what the law requires of them. This would both aid the court in record keeping and be potentially life-saving to victims of domestic violence. Courts should have the ability to verify that existing law is being followed and that the third-party transferee is eligible to possess guns. We cannot implement the law on an honor system. Domestic violence survivors deserve better. Since January 2025, our volunteers have visited and observed orders of protection hearings all over Tennessee. To date, we have met 21 judges, all of whom hear orders of protection cases. Not one judge has told us they think the third-party transferee information and signature should not be on the dispossession forms. Judges in 10 Tennessee counties have already taken the initiative and modified the forms their court uses. They include Scott, Wilson, Davidson, Shelby, Putnam, Polk, Cheatham, Dixon, Murray, and Knox counties. From what we have observed, Tennessee judges want to do everything they can to separate domestic violence survivors and their armed abusers. While we are glad to see judges make this important change, this council has the power to expedite this form change and create a statewide standard for courts to follow. The council should provide more protection for survivors of domestic violence by updating the dispossession form to include the name and information of the third-party transferee who will be taking hold of the abuser's firearms. It is wrong to allow victims who've been granted an order of protection to leave the courtroom thinking their abuser will relinquish their guns when the truth is that enforcement is often weak and non-existent. Updating the dispossession form is a small step. It closes the gap in implementation. Legislation was filed in the General Assembly last winter that would update the form, and while we are encouraged the General Assembly is taking interest in action, the change would not become effective until almost a year from now, if it should pass. Domestic abusers with firearms are 5 times more likely to kill their female victims. Victims cannot wait. You have the authority to help victims now by updating the state form and requiring every domestic abuser subject to an order of protection to identify their firearm and where their firearm is going. Under TCA 363625E, the DVSCC has the authority to develop an affidavit of firearms dispossession form. The Tennessee law requires domestic abusers under these orders to dispossess themselves of firearms temporarily. The change helps law enforcement and courts to ensure this law is implemented effectively. Separating guns from dangerous people is one way we can save lives in Tennessee. Please use your power to improve implementation of existing legislation and update the dispossession form. Would like to thank all comments that were received. And again, we did distribute all comments that were received, regardless of their timeliness, to the council for consideration in advance of new business. So I want to stress that for the purposes of the meeting. We'll now move to the next section of our agenda, which is new business. I would like to publicly thank Judge Inslee Hagen, the Division III General Sessions Judge of Wilson County, for presenting to the council at our last meeting on December 5th as to the firearm dispossession form issue. The firearm dispossession form has been a topic discussed among the council for multiple meetings. The issue has been considered by our Emerging Issues and Order of Protection Committee as well. At this time, the AOC nor the legislature has updated or adopted a modified dispossession form. As stated in the previous comment that was read, counties such as Wilson, Scott, and Putnam have modified their own forms to provide a greater accountability in firearm dispossession. We continue to receive multiple comments in advance of each meeting, and there does appear to be judicial support for this council to set a precedent, even if it is symbolic. It is the AOC and the legislature who are actually charged, as members of this council may know, with form adoptions. Given that the AOC and the legislature has not acted to formally adopt a form, I would like to make a motion to the council that we recommend that each jurisdiction implement a modification to the firearms dispossession form, consistent with the modifications that were adopted by Judge Hagan in Wilson County, who presented to our council at our last council meeting. His form was distributed at the last council meeting. Those modifications would be included on page 2 of the state form that was adopted in 2017, entitled State Form OP 2017-6. Now, because of the council's limitations, my motion is to recommend that each jurisdiction make their own modification and implement that form. Those modifications would include a new section that the receiver of the firearms be required to execute the dispossession form to include that they are over the age of 18 and legally allowed to have firearms in their possession, that they acknowledge that an order of protection has been entered against the respondent, and that he or she, that they are acknowledging that that person shall not possess firearms while the order is in effect, and that they are agreeing to accept transfer of the firearms, and that they agree that the receiver agree to not allow the respondent to take possession of his or her firearms prior to the expiration of the order of protection. And so that would be my motion to the council as to the modification of the form. To implement that modification, I would, as a part of my motion, I would recommend this council send a formal letter be sent by the DVSCC to the judicial conferences of the trial judges and the general sessions judges, identifying for them that we have recommended the firearms dispossession form be modified, and that we provide them with a copy of a proposed modified form. I've made a motion for the council. Is there a second?
A second.
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 We have multiple seconds on the floor. Is there any further discussion on the dispossession form modification beyond the comments that I have made, which has basically summarized the issue that we have continued to address through the council? Any further discussion?
Chair
How
Lady, I would
quickly would, I'm sorry.
I'll recognize Michelle Consiglio Young first.
Thank you. So I just want to make a clarifying statement on your comment that as an employee of the Administrative Office of the Courts, I do want to clarify that the AOC does not have the authority or decision-making ability to change forms with changes that are not promulgated by statute. That is our policy. Those are procedures that we follow at the AOC for form creation. We welcome the General Assembly to change the code, and we will happily incorporate those changes into forms that we create. This particular form, the authority, as stated previously, is with the Domestic Violence Coordinating Council to create that form as seen fit. But I just want to clarify that the AOC will make changes as promulgated by statute, and that's the procedure that we follow. And I've also stated on previous meetings, I'll put on the record again, that I'm unable to vote on this particular action item just because of my position with the AOC and it conflicts with our form promulgation procedures. So I will be abstaining.
Thank you. Thank you, council member, and thank you for that clarification. I think I did state the AOC and the legislature. Of course, you are correct that technically you implement what the legislature puts in effect, and those implementations have not been made at this point by the legislature. Did council member Michelle Mallory Johnson ask to be recognized?
Yes, thank you. If this motion passes, can we give a timeline for when this letter and these recommendations would go out to the judicial districts?
It's an excellent question. I would recommend and can amend my own motion to include that letter would be distributed within 30 days.
Thank you.
Is there any further discussion on the motion? All right, I would recognize Becky Bullard.
There's a clarifying question. So is the motion to create a recommendation versus the council changing the form?
I would like Michelle to readdress that issue because the Domestic Violence State Coordinating Council, to my understanding, has some limitations. And the legislature, if they are responsible for adopting forms, it's my understanding that all we can do is recommend. Michelle?
So the statute gives specific power to the DVSCC to create this particular form.
Okay, thank you for clarifying that. So then I would modify my motion that we adopt the modification and distribute it accordingly. I would like to recognize Chelsea Curtis, please. Councilmember Curtis?
Yes, sorry. I just kind of wanted to clarify that as well. The legislature, there's a couple of bills that are pending. I track bills on behalf of the Public Defenders Conference. And I'm, full disclosure, not fully up to speed on every piece of legislation that might touch the Domestic Violence State Coordinating Council, but I am aware of at least 2 bills that deal with the council. And Becky, I know you just mentioned, do you have the code handy, perhaps like the TCA, so I could look up like where that says, because I'm also under the impression that this vote may be more of a
symbolic
vote, yes, than actually binding to any of the counties.
I think the statute, Chelsea, is 363625.
65. Okay.
That was the statute that I was looking at prior to the meeting, which doesn't mention the Domestic Violence State Coordinating Council. Michelle may have a different statute, or Becky may have a different statute.
Yes, that is the correct statute. It really needs to be read in full. You read the entire 363625, but I will specify that 363625E reads as follows. The affidavit of firearms dispossession form shall be developed by the Domestic Violence State Coordinating Council in consultation with the Administrative Office of the Courts. Upon completion, the form shall be posted on the website of the Administrative Office of the Courts, where it can be copied by respondents or provided to them by the court or the court clerk. And that being said, if any forms are promulgated by the council, the AOC will post it and stating that that is a form promulgated by the council on the website, along with the other order of protection forms.
Chelsea?
Yeah, so, I'm happy to vote for, sending out a letter and saying, hey, this is something that's come to our attention, but I'm a little bit hesitant. I know there's a lot of organizations who are calling for the council to do something about this, but I would urge those members of the public who may be on this call to contact your legislators, because that's really how the change can happen. And like I said, I'm aware of at least 2 bills that are pending dealing with the Domestic Violence State Coordinating Council. And I don't know that the council has the power to do what some members of the public are asking us to do. So I just wanted to put that on the record. Thank you.
Any further discussion from a council member? So Chelsea, my original motion was to recommend sending it to the judicial conferences based upon the discussion with Michelle clarifying the statute that the DVSCC does have the power to officially modify that that form. The statute does say the Domestic Violence Coordinating Council in consultation with the administrative office of the courts. I think what your concern is that the lack of consultation with the administrative office of the courts.
I read that statute and that piece, and I see that it says that we can develop that with the consultation of the AOC, but Michelle can correct me if I'm wrong, but doesn't that kind of knock against the AOC's policy of only promulgating forms that are kind of demanded in law? I mean, typically, like I said, I don't monitor bills on behalf of anybody other than the public defenders. So any bills that I see about, forms that the AOC is promulgating is kind of secondary to my primary role. But, typically when we're getting new forms, it's something that's passed in statute. So I guess I'm just a little bit uncomfortable as a council passing something. I just don't want that to seem like we're kind of doing something that we may not be allowed to by law. Like I do read this subsection E, but to me that's not super clear that we can just say, hey, every court in the state has to adopt this form. I mean, judges are elected, they follow statute. If we vote on this and send out this letter, I think that's great. I think that's symbolically, there is power in symbolically doing that. But I don't know that that would cure the issue. So I think I'm more so encouraging members of the public to take this a step further than the council and to actually seek change in statute to make it very clear, whatever kind of third-party dispossession form that they're seeking.
All right, then Michelle.
Yeah, I mean, I'll echo what Chelsea said, and that's been the position of the AOC the entire time. And our Order of Protection and Emerging Issues Committee has dealt with this for a very long time and ultimately could not come to a consensus. That was described in the December meeting, so we just sent it with no recommendation to the larger council, and that's the same issue that we run into at the AOC, that our committee ran into, was that yes, the code does specify within the full section that the Domestic Violence Coordinating Council can develop the form, but that has to be read within the entire statute that also promulgates what lawful dispossession means, and that those components are listed in the statute, and without the specific information that is being presented right now being added to the code, that is not something that can just be done without legislative action.
All right. Thank you for that explanation. Thank you, Councilmember Curtis and Councilmember Consiglio Young. I think that was my initial concern when, and I can see how members of the public might misread the statute. And I think that explains the quandary that the council may be in. My original motion that I believe was seconded was to recommend that each jurisdiction implement a modification and to send that be sent by formal letter, and based upon the further discussion about whether that should be, there would be an amendment to that original motion. So I'll leave my motion that has been seconded I'll leave that as it stands. And based upon further discussion, are there members of the council who are asking to be heard on this issue? I recognize that there are members of the public who are who have raised their hand for discussion. Those same members who have raised their hands for discussion, those same members of the public who have raised their hand for discussion have given public comments, and their public comments have been considered. I do not want you to think that you are being disregarded. Do not want you to think you're being disregarded. We want you to know that the council has heard your public comments, and but that public members do not, during the discussion of motions at meetings under the Roberts rules, are not included in that discussion. Becky, you are a member of the council, correct?
No, I'm not.
Okay, thank you. All right, thank you for identifying that. All right, so the motion before the council at this point is for the council to recommend.
Before we do that, I do want to.
Yes, Brandon, go.
The council does have the authority to make amendments to the forms. Whether or not judges will implement those forms will be left to the judges.
Right.
But the statute very clearly gives us the authority to make that amendment, and that amendment or that new form to be published. Again, if this is misconstruing what some concerns are, I think it just needs to be abundantly clear. We can amend the form. We can publish the form. It'll be left to the judges whether or not they want to adopt that in their jurisdiction.
Thank you, Brandon. All right, so the current motion, I'll restate the current motion, which has been seconded. If there's, based upon the discussion, if there's any motion to amend the original motion, then we will entertain that at that time. Motion at this time is for the DVSCC Council to recommend a modification that each jurisdiction implement that modification, that proposed modification to State Form OP 217-6, and that modification would include new sections that are consistent with the dispossession firearm form that is currently being used in Wilson County. Is there any? That is the motion that has been seconded. Is there any further discussion on the motion by a council member? Seeing none, hearing none, I would ask that the secretary call the roll on, in just a moment, call the roll on the pending motion. And I would like to reiterate and note Councilmember Consiglio's Young's statements that we do have members of this council who, by their employment or their position, may have a need to abstain or be present but not voting. And I would encourage members of the public who may be viewing this this meeting, or who may later view this meeting on the coalition's website, to understand that some members of this council may be unable to vote on the proposed motion due to their position, and that they should not draw any negative conclusions from that. Mr. Secretary, would you please call the vote?
Yes.
We'll call the roll.
Starting off with Chair Member Melanie Bean.
Aye.
And Chair Member Michelle Consiglio will be abstaining. Council Member Chelsea Curtis.
Aye.
Council Member Sue Jones. Council Member Deborah Lambert.
Aye.
Council Member Van Makers.
Aye.
Council Member Kirby May.
Aye.
Council Member Michelle Johnson.
Aye.
Council Member Ashley Parker.
Abstain.
Council Member Kendra Reeves.
Aye.
Vice Chair Judge Jenny Scott.
Aye.
Councilmember Ilana Tate,
Aye.
Councilmember Felix Fess,
Aye.
and I'm an aye.
Motion carries. And we can, within 30 days, we will issue the recommended modified form to be implemented in each jurisdiction. And we will include the sample form for each jurisdiction. And we will send that modified form to the judicial conferences, distribution to the circuit sessions and chancery court judges who are adjudicating orders of protection, and ask that they implement the modified form, which will be consistent with the form currently utilized in Wilson County. Is there any other new business that needs to be addressed? Hearing none, seeing none, our next proposed meeting dates for 2026 is June 5th, 2026, September the 11th, 2026, and December 4th, 2026. Are there any other questions or comments from council members from this morning's meeting at this time? Hearing none, seeing none, I would like to thank you for your time this morning and your important work that we all do for Tennesseans. I would like to echo the statements of Councilmember Curtis about contacting your legislator and to engage in the legislative process so that we can continue to protect all Tennesseans, and to give the Domestic Violence State Coordinating Council the funding that is needed to continue the work that we're currently being hampered in some respects, that would work toward assisting all Tennesseans. All right, with no further comments or business, this meeting will officially be adjourned at 10:52 a.m., March 6, 2026. Thank you for your attendance.
20. Aye.